Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, we are going to look at the question of, is it illegal to spank your child? If you find this video helpful, please subscribe to the channel, like the video, and hit the notification bell so you can be notified when videos hit. Thank you so much to all of you who have subscribed to the channel, still holding strong over 8,000 plus, and would love to have many more. So thank you so much for your support, and please put in comments what your thoughts are as we go through this very important discussion. One of the questions that I often get in my family law practice, as well as in relation to domestic violence cases, is, am I allowed to spank my children? You know, am I going to be arrested? You know, what is the law on disciplining children? Because the way that it's portrayed by the media and in other places, you would almost think that you're never allowed to engage in corporal punishment, but that you always have to use some sort of alternative form of punishment, like timeout, you know, taking things away, or, you know, people who don't even believe you should punish your child, they engage in positive reinforcement. But what is the law as it relates to spanking your children and the ability of a parent to do that? When it comes to the issue of spanking children, is really a subset of assault and battery. And I've done several videos, including the Will Smith video and a couple other videos relating to assault and battery and what they mean. But that is what spanking is. Essentially, it is the infliction of a unwanted or harmful touching with the intent to create that harm. And so that is what an assault and battery is. If you're hitting someone and they don't want to be hit, and you know, you don't have any reason or justification or excuse, and you hit someone, generally that is an assault and battery. But the law is much more complex when it comes to the issue of discipline and spanking. So I want to talk to you about a case that just came out this week on May 3rd in the Virginia Court of Appeals, and kind of walk through that opinion and explain to you what the rights are of a parent in the issue of discipline and spanking children. So the name of the case is Tina Woodson versus the Commonwealth of Virginia. Miss Woodson was charged with an assault and battery of her two children. They were twins, and so she was ultimately found guilty of spanking the children with a belt without using the buckle, just the belt portion, and use that to spank the children. The children go to school. They tell the school resource officer that they're afraid to go home because of the issues that are at home. Apparently, they also allege that there was some sort of abuse by the father, and so they were afraid to go home, but they didn't specifically say they were afraid because of the mother spanking. So the state prosecutes a case against Ms. Woodson for misdemeanor assault and battery, and is tried before a court, and the judge finds her guilty. And essentially the issue is that the children had a cell phone. They were not supposed to give the number out to people that the parents hadn't given permission to. One of the children had given that because the mom caught one of the children with the phone communicating or receiving a communication from somebody else. They lied about it, and so mother told them to get a belt, and she spanked the children. According to the opinion, there was no serious harm. There was some bruising that was typical for being temporary bruising, temporary marks, but no serious injury. But the judge at trial said, well, look, this was a texting violation. This is something so insignificant. You should have punished in some other way. And the fact that the pictures don't show everything, the damage that was done as a result of the spanking, I've seen enough. I'm going to find you guilty of the assault and batteries. And so she does. And then the mother appeals to the Court of Appeals of Virginia. The opinion by the Court of Appeals is written by Judge Lisa Lorish, and it came out on Tuesday. And it starts off by saying this: Virginia, like every other state, permits parents to discipline their children with corporal punishment. So she is making an assertion that every state allows this. Now, I have not done research into all 50 states to determine if that is in fact the case, but I'd take the judge's word for it that because of the long-standing nature of corporal punishment and parents' rights to be able to discipline children, I would say that that's probably accurate. But she makes the assertion that every state allows for this. It's called the parental privilege. The parental privilege excuses what otherwise would be battery in the ordinary course. And in order for it to pass muster, to be allowable for parents to do this, it must be reasonable and not excessive. Now in Virginia, there's a list of factors, and I'll go into those as we move into the opinion. There's a list of factors that the court looks over. But at any rate, discipline is excessive if it inflicts significant physical harm on the child. And they define that as it's readily evident from the presence of more than transient physical pain or temporary marks. So if it's something that causes some temporary pain or some minor marks, things that are going to go away shortly, then that is not significant harm in the minds of the Court of Appeals of Virginia. The opinion then goes into the facts and the testimony of what happens at the trial, and then ultimately writes what the analysis is under the law. It says a battery is a willful or unlawful touching of the person of another by the assailant or by some object set in motion by him. It's one who engages in an overt act intended to inflict bodily harm and has the present ability to inflict such harm, or engages in an overt act intended to place the victim in fear of or apprehension of bodily harm and creates that reasonable fear or apprehension in the victim. An intentional touching qualifies as a battery unless the actor has some legal justification. And they list what some of those are, such as self-defense, consent, and other things. But then they center on the parental privilege. It says relevant here is another domestic authority, which is sometimes described as the parental privilege to discipline a child with force. After going into some of the procedural aspects of the law, the judge then goes into the actual use of corporal punishment must serve the well-being of the child. A parent has the privilege to discipline his or her child within the bounds of moderation and reason. This discipline may include corporal punishment. Because the privilege must serve the well-being of children, there are limits. So in other words, if you're going to engage in spanking the children, it has to be for the benefit of the child. It can't be because you've flown off the handle, they've aggravated you, they've made you mad. It needs to be for some reason that you are trying to teach them or educate them or help them in some way, discipline them so that they learn not to do something again. It is not just something where you are lashing out because you're mad at them that they've messed up your day, or that you're angry at them because they're, just being kids. You don't get to do that. It has to be used in a way that is benefiting the kids. The judge then goes into the policy behind this, and I thought that this was very interesting. He says, in this way, the privilege generally serves the well-being of children, reflecting a trade-off between protecting children from the harm a parent may inflict and the harm that comes from unnecessary state interference. I don't think I've ever read an opinion where it says something like that. I'm sure that there's one that exists, but I have not read it. But wow, that's talking about the balance between being able to live your private lives and make sure that people are protected, but at the same time, not allowing the government to step in and be, de facto parents and coming in and telling families how they need to do things, because they're wanting to intrude in the ability of parents to be able to raise the children how they see fit. The court in this opinion actually calls that a harm of unnecessary state interference. I thought that was fascinating language. In this way, deference to parents provides a particularly important shield for low-income families and families of color who disproportionately experience state intervention. Now, I can tell you that as a custody lawyer and as one who has spent a decade in the past serving in the court-appointed community where there have been abuse and neglect cases, I have seen overwhelmingly a disparity in treatment between racial minorities and non-racial minorities in the intervention of the state. I have seen cases where I believe that children would never have been pulled away from the families if they had the same skin tone that I did. But because they had a different skin tone, they were treated differently. And I could be wrong. Maybe I am. That's just my opinion from having actually served in the trenches. There have been several cases that I've argued would never have been brought And it's just based on what I've seen. It's very anecdotal. Don't have any facts to support it other than what I've seen. But I would definitely not disagree with that. And obviously, this judge believes that that's the case as well. So when we allow the state to interfere and impede the low income people who don't have the resources to be able to hire attorneys, to be able to fight for their rights, to be able to provide more services for their kids on their own, will generally see more government influence intruding into their lives, offering to provide services to them. So there's certainly a need for that in some families, but I'm not going to disagree with what the judge has to say here about seeing the disparate treatment. The court then gives the factors that determine whether something is excessive. The courts are to look at the age, the size and conduct of the child, the nature of the misconduct, the nature of the instrument used for punishment, and the kind of marks or wounds inflicted. The emotional state of the parent is also another factor. Parental privilege to discipline cannot be used as a cloak for the exercise of uncontrolled passion. So parents can't just fly off the handle and lose their minds and just go crazy on their kids because they can't control themselves. Parents need to be under control if they're going to engage in this type of discipline. Now, the court notes that there is one aspect that all of the previous cases that have been decided have in common, and that is once corporal punishment exceeds the significant harm threshold, the inquiry is over. So if there's evidence that there is significant harm, then that's it. There's bleeding, pussy wounds. There's broken bones. There's welts that require hospitalization over a period of time that's more than just temporary marks. Case closed. That's excessive, and according to the court, that's going to rule the day. But even if there isn't significant harm, there could still be risk of significant harm, which is why the court still has to go into those factors to determine that if there was a risk of significant harm, could they still be found guilty based on the damage that had been done. And so all of those other factors still come into play in determining that risk assessment by the court. But what this judge does note is that it is not the place of the court to substitute their own judgment for that of parents when it is not a case of significant harm or risk of significant harm. She says this: allowing every trial judge to substitute their own parenting views for that of the parent would conflict with our clear precedent permitting reasonable corporal punishment and insulating routine parenting decisions from state scrutiny. So this judge is giving a very libertarian opinion here, and essentially saying, look, the government doesn't need to come in and second guess what parents are doing in the ways of discipline or in other ways, as long as it is not causing a significant harm or risk of significant harm. Then the courts need to stay out of it. The state needs to stay out of it and let parents be parents and let them take care of their kids how they want to do it. So this is a very anti-government opinion. At the end of the opinion, the judge sums it up by saying, parenting is an inordinately difficult task, and a criminal prosecution cannot rest on a debatable parenting decision without other evidence that the conduct was excessive. Disagreement with Woodson's decision to use corporal punishment combined with evidence of only transient marks from the soft end of a belt falls short of what a reasonable fact finder could conclude is excessive. We conclude that the evidence creates only a suspicion or probability of guilt and falls short of what a rational trier of fact could find excessive beyond a reasonable doubt. As a result, we reverse and dismiss. So essentially, this justice is calling the trial judge an irrational fact finder. She says that no rational fact finder, no rational jury, no rational judge could be able to find that this person was guilty of this offense. That is a very seldom used law. I mean, there are very few cases that are overturned after they've reached a full conclusion and reached a verdict that get overturned based on this rational fact finder argument. This is a huge case that doesn't just turn on de novo review, but also is essentially on its facts, saying nobody could have found this to be more than just a probability of guilt or suspicion of guilt, essentially blasting the trial judge here for invoking herself as the parent of the in place of Woodson here. So what are the takeaways here? Number one, as parents, you have the right to be able to discipline your child. You can use corporal punishment. It is legal. It is not illegal to engage in corporal punishment in the general course. But if it is not for the benefit of the child, if it's excessive, if it is because you can't control yourself and you're just angry flying off the handle, that will not be sufficient to protect someone in the event that they do engage in corporal punishment. So if you're getting to the stage where, you know, engaging in corporal punishment is a regular thing, then you may want to seek out some help and some assistance. You don't have to go to the government to do this. There are parenting classes online. There are anger management classes online. You can get involved with a church and get some counseling from a church. You can meet with a psychiatrist or a psychologist or whatever you need to kind of, or maybe even a parenting coach or life coach or something to help you, you know, be able to maintain control. And, you know, if there's, again, nothing wrong or nothing illegal with engaging in corporal punishment, but it shouldn't be, number one, anything that's really celebrated. We shouldn't be excited about it. It should be something that if you engage in it, it really breaks your heart that you have to do it. But it should really be one of the last things that you have to engage in order to go forward. I mean, but at the end of the day, it's not the state's place to jump in, as the judge has said, as the justice said, and replace their decision making. So, you know, kudos to her for trying to keep the government out of things. But at the same time, don't allow this to be a reason for you to be abusive either, because there's not much in the way of protection for that. So, again, I'm Drew Page. Thanks for watching this video. Hope it was helpful and informative. Please subscribe to the channel, like the video, hit the notification bell, and until next time, stay tuned.